Courts are unlawful. All courts are privately owned trading companies. The United States District Courts are all owned. Those are your Article I courts. They're all owned by the United States Attorney's Executive Offices out of Washington, D.C., which is a privately owned corporation. They are Article I legislative tribunals, and they're not courts. They have DUNS numbers. They have a PIT code, a SIP code, NAICS number, that's North America Identification Security Classification. You have to have that number in order to trade internationally. You see, all these courts are registered with the Department of Defense. They have a DUNS number, which stands for Data Universal Numbering System, from Dun & Bradstreet. You have to be registered with CCR under the DoD. They have another department called the DLIS. That's the Defense Logistics Information Service. The DLIS issues a case code that's called CAGE for Commercial and Government Entity, which corresponds to the bank account. Courts have a bank account. They take everything you file into the court and they securitize it. The banks are registered. There's a depository agreement, a security agreement, and an escrow agreement. And most of them are registered with the Federal Reserve Bank of New York City. They take the public funds and they deposit them under what they call a depository resolution agreement. And the clerk of the court signs a security agreement with the bank. An escrow agent acts as a go-between the Federal Reserve Bank that they have an account with. So all these courts are taking your money and funneling it into an escrow account, most of which are in New York. There's $60 trillion of your money in the Federal Reserve Bank of New York City. And they've told the courts not to rule against the banks on foreclosure cases. They're all in bed together. The lawyers are acting as private debt collectors. In the U.S. Code, it's called the Debt Collectors Practices Act, under Title 15, Section 1692. The Code of Federal Regulations has the Fair Debt Collections Practices Act, the FDCPA, in Section 16. In order to be a public debt collector, you're supposed to be licensed and registered with the government, and you have to have a bond in order to collect debt. Well, these attorneys are what you call private debt collectors, and so they're exempted by the Bar Association on that provision, but their firm is not. The firm they work for has to be registered, and they have to have a license and a bond, but they don't. In all court cases, attorneys are acting as private debt collectors. They collect money from the people as private debt collectors, and they're not licensed or bonded to do that. But they do it through what they call warrant of attorney. Black's Law Dictionary of 1856 defines a warrant of attorney as a writ of execution, like a put or a call. When you do a margin call, that means they use it to buy equity securities because they securitize everything that you file into court, which means they turn it into a negotiable instrument. Then they sell it as a commercial item. They call them distressed debt, these debt collectors do. That's what Unifund is. They come in and buy up all these court judgments as distressed debt. Then they put them into hedge funds, and they sell them to investors internationally. And of course, when you get into selling debt instruments, you're creating a security risk. And anytime you get into risk management, you have to have reinsurance. That's where Lure Hermes comes in. They're an underwriting company, a subdivision of Alliance SE out of Munich, Germany. And the U.S. agency that acts as a bondholder for Alliance SE is PIMCO Bonds, who takes all your securities and they pool them. And that's what they do on these mortgage loans. Go to their website and it'll tell you that's what they do. All of your mortgage loans are securities. The notes have a maturity of more than 9 months, so they're a security by definition. If you go to Title 15, Section 77A(b)(1), It tells you that any note with a maturity of more than 9 months is a security by legal definition and an investment contract. So when you sign and endorse these notes as the drawer and the maker, you're in an investment contract, and you gave them a security. They take the security and securitize it. As soon as they've endorsed it for payment, they've securitized it. The loan is no longer secured. They've collapsed the trust, and there's no corpus in the trust under probate law. What they do is sell it as a mortgage-backed security. PIMCO takes the mortgage-backed security, pools over, and sells them as bonds. So bonds actually come from pooled securities, and they sell these on the TBA market globally. And all these courts are involved in that.